Creating an official last will and testament in Montana can go a long way when ensuring one's estate is properly managed upon death. Best of all, will documents can often be made without seeking legal advice from a pricey lawyer. In this video, we'll discuss the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Montana, and how and where to create an official will. Let's begin by looking at wills and their importance. A last will and testament, also simply known as will, is a written document that sets instructions on how an individual's property is to be distributed after their death. Wills determine who the beneficiaries of the deceased estate are and the amount they'll receive. It's highly recommended for all adults to have a will, particularly those who are elderly or facing life-threatening conditions. Now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Montana state law will decide how the deceased assets are managed. In these cases, the deceased spouse or children typically inherit the property by default. Disputes can commonly arise between loved ones regarding rightful heirs when the state, through its court system, handles and disperses the estate. Fortunately, one can avoid any uncertainty by drafting a clear will document, and often without an expensive attorney required. A person of sound mind can draft a will in Montana with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witness signatures. And finally, let's review some of the legal requirements in Montana. Last will and testaments in Montana must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though it's optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to trusted individuals such as the executor of the will for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Montana that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.